Breaking Down the Law is sponsored by Battle-Born Injury Lawyers.
All right, before we get to Matt Hoffmann, this is the topic we're going to be discussing. We take a live look at the remembrances that are taking place in honor of Justice Ruth Bader Ginsburg. She is lying in repose at the Supreme Court today and tomorrow, so members of the public and those who love and knew her best can pay their respects. Actually, she'll become the first woman to lie in state in the U.S. Capitol tomorrow, and she died last Friday due to complications of pancreatic cancer, serving for some 27 years. All right, so her passing leaves a vacant seat on the U.S. Supreme Court less than 2 months before the November election. President Trump says he will announce a nominee Saturday, promising it will be a woman. The leader of the Senate, Mitch McConnell, is pushing for a vote before the election. Democrats claim Republicans are being hypocrites, pointing to the decision to block President Obama's nominee back in 2016. So how will all this play out? Here to discuss it, Matt Hoffmann with Battle-Born Injury Lawyers. So first of all, as always, good to have you, Matt. So let's just start with the politics process, that is. Let's take the politics out of it. What is the process for appointing a Supreme Court justice?
Thanks, Crystal. Yeah, I think the process is what everyone needs to focus on. Where the politics comes in is everyone's focused on what the result is going to be. But the process itself is the same for President Trump as it was in 2015 for President Obama. So Article 2 of the Constitution, and I'll read it, it says that the president shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. And in the law, the word shall has legal significance. If something says a judge may do something, that means the judge has discretion. But if it says the judge shall do something, they have to. And here in the Constitution, it's saying the president shall nominate judicial appointments. And so the president has to. And that's their job. And they swear an oath to uphold the Constitution. And that's why back in 2015, President Obama nominated Merrick Garland to fill the vacancy of Antonin Scalia. And that's why this weekend, it sounds like Saturday, President Trump will nominate somebody to fill Justice Ginsburg's seat. Where it gets hairy is in this advice and consent of the Senate. So, going back to 2015 and really 2014, in 2014, there was a midterm election, and the American people gave a Democratic president, Obama, a Republican majority in the Senate. And so when he nominated Merrick Garland, he needed the Senate to approve it. Well, the Senate was Republican, and they have the right to just not approve a nomination. In that case, they chose not to have a hearing, but that is their right. They don't have to nominate anybody or they don't have to approve anybody that's nominated by the president. Whereas now, since that happened in 2016, you had a Republican president elected, that's President Trump, and you had a Republican majority in the Senate. And then in 2018, recently, that majority in the Senate actually increased to 53 members. So what we have is a very simple process that's laid out in the Constitution. The difference is you have a Republican president and a Republican majority in the Senate. And, again, people focus on what the outcome is going to be because the president's going to nominate somebody, and I think it sounds like the Senate's going to approve them. But if the shoe was on the other foot, does anybody really believe a Democratic president with a Democratic majority in the Senate would do otherwise? I don't think they would. And so the process is what it is, as laid out in the Constitution.
Well, let's talk about the fact that this election is less than 50 days away, and many are saying this is a lifetime appointment. This is something we maybe not want to push through regardless of who has the upper hand, Republicans or Democrats. Let's talk a little bit about that.
Yeah, there's no rule on how long it's supposed to take. Justice Ginsburg was confirmed within 44 days, I think. But the example I would look at is 1975. Gerald Ford nominated John Paul Stevens, and he was nominated and confirmed in 19 days. And the reason I point to that one is, the country seems very divided right now. Well, Gerald Ford was only president because President Nixon and his vice president, Spiro Agnew, had both resigned in shame after Watergate. I can't think of a more tumultuous time than 1975. And despite that, John Paul Stevens was nominated and confirmed in 19 days. So I don't think the timeline really matters here. And also back then, that was under the old rule where you needed 60 senators, not a simple majority, you needed 60. And the reason, and now we just need a simple majority. And the Nevada connection to that is our Senator Harry Reid. In 2013, he changed the rules for judicial nominees from a 60-person Senate majority to a simple majority. And so in whether you like this result and what's going to happen or you don't like it, in many ways you can thank Senator Harry Reid for making it possible, because even if it's a tie, even if it's a 50-50 split, it's the tiebreaker in the Senate is Vice President Mike Pence. So from a process standpoint, I don't think there's any stopping what's going to happen, and it's going to go through.
Well, Matt Hoffmann, appreciate your insights on that, and we will definitely keep a close eye and ear on everything that unfolds. All right, we'll see you next Wednesday.